Today I will show that the United States acted in accordance with international law when it enticed Mr. Rwanda from Canada to the United States. Further, my co-agent, Ms. Kang, will demonstrate why...
Entice. I love these adjectives that are being thrown around this court by both parties. What do you mean by entice? I thought it was lure, and I've heard some other words as well. I even said ruse, and I didn't mean it, but please, let's get the adjectives correct. But entice, is that an adverb? I'm not sure. It's a verb, that's right.
Your Excellency, courts have used many words to describe this action, including luring, enticement, trickery. This is just one of the many words that courts have used.
And you're going to use that one as opposed to learn?
And luring.
All right, proceed.
Further, my co-agent, Ms. Kang, will demonstrate why the United States should be allowed to transfer him to Rwanda so that he may stand trial for the grave crimes he is suspected of committing during the Rwandan genocide. Your Excellencies, the enticement, or luring, did not violate international law because, one, it did not involve a physical intrusion into Canada's territory. Second, the United States-Canada extradition treaty and the exchange of letters do not apply to the current case. Even if they do apply, they do not prohibit luring.
And why is that? Are you going to tell us?
I am, Your Excellency.
Proceed.
And finally, Mr. Rwanda's human rights were not violated because his arrest and detention were lawful and not arbitrary. Because Your Excellency seems concerned with the extradition treaties, I'll begin with that point.
That's a fair point.
First, the extradition treaty and the exchange of letters do not apply to the current case, and even if they do not prohibit luring. The Vienna Convention on the Law of Treaties, in Article 31, states that a treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms in their context, and in light of its object and purpose.
And would you call some reaction to the United States by going against at least the spirit of the extradition treaty? Would you call that acting in good faith?
I would, Your Excellency. The fact is, this court has looked at the meaning of good faith in the case of Costa Rica v. Nicaragua. And this court found that good faith means in line with the parties' common intention. Now here, the United States and Canada never intended for luring to be prohibited.
What did they intend by passing a comprehensive regime concerning the extradition of individuals?
The preamble goes to the intention of the parties, and it states that the states desire cooperation in the repression of crime. Now, surely cooperation is a way to fight crime. However, states do not sign extradition treaties to be friendly. They sign it to punish criminal activity and to prosecute criminal activity. Now, nowhere in the extradition treaty does it state that formal extradition is the exclusive means of obtaining a defendant. And in fact, neither document explicitly prohibits luring. The exchange of letters that Canada points to does not prohibit luring. In fact, it only speaks to trans-border abductions by private parties, and specifically states that it is not creating a legally binding obligation between the parties. In fact,
why didn't the United States just call up their colleagues in the RCMP? I think they know each other and work this out.
The RCMP, Your Excellency?
Royal Canadian Mounted Police.
And work it out with them?
Yeah.
Canada had stated to Rwanda several times that it was not going to extradite Mr. Rwanda.
They can say that politically, but certainly two police agencies can sit down and talk, can't they? I know it's probably not in the facts, but the logic here is why are we dancing around rather obvious choice?
Your Excellency, it's possible that the two states could have sat down and worked through this. However, that there was an alternative for the states does not mean that the United States violated the terms of the extradition treaty. And in fact, if the two states did intend to go back to the intention of the parties, if they intended to prohibit luring with the treaties, when they amended the treaty in 19...
Like bad faith to me, they say, well, the Canadians are going to, they're not going to give them to us, so we'll just go ahead and take them anyway. Is that bad faith?
Your Excellencies, respectfully, no, it is not bad faith because it's not in line with the common intention of the parties. As Canada submits itself, it lured 2 U.S. citizens in 1973. That was 2 years after the extradition treaty was signed between the two states.
But isn't it a principle of law that it evolves and that countries can change their practice? And actually, that's reflected in international law.
Yes, countries are free to to change their practice. And if Canada, once it changed its position on luring, which the United States was not necessarily aware of, but once Canada changed its position, it could have amended the treaties.
So every time some cop finds a new way of getting somebody across the border, you should amend the treaty. Isn't there something to be said for the spirit of an agreement, as well as its letter?
Yes, Your Excellency, there is something to be said for the spirit. However, here, Canada and the United States both knew that both countries had participated in luring. In fact, the United States had participated in it in 1985 in the Eunice case when it lured an Lebanese citizen into the United States. And since there were amendments in 1974, 1988, and 2001, if the parties intended to prohibit luring, they could have done so in any of those amendments. And
The Eunice case, you're talking about the 1985 case?
yes,
They lure him in the United States? Are you sure of those facts?
they lured him onto a yacht and then later
Yes, and where was that?
That was on the high seas, Your Excellency.
In international waters?
Yes, Your Excellency. However, the United States was participating in luring, and this just goes to show the United States and Canada both knew that this wasn't some minor act that may happen, but the fact that both states knew that it was happening on a large scale, and in fact internationally there are many other cases of luring.
So, he stole the cookie, I stole the cookie, he stole the cookie again, therefore we have customary intentions here. So they were saying just because one side does it, the other side can do it?
No, Your Excellency. If there had been a violation of the extradition treaty, that doesn't necessarily mean that the next side gets to violate it. However, we're arguing that Canada did not violate the extradition treaty when it lured the two U.S. citizens in 1973. We're just using that to show that Canada never intended for the extradition treaty to apply to luring specifically. They only, at most, intended it to apply to transport or abduction, and in the case of the exchange of letters, private acts of transport or abduction.
Right, proceed, your argument.
Also, the United States did not breach Canada's territorial sovereignty because there was no physical entry into Canada. The UN Charter, Article 2, states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. This court found in Nicaragua that it is customary international law that every state has a duty to refrain from force or the threat of force to violate the existing international boundaries of another state. Now, Canada conflates the idea of political independence and territorial integrity. However, those are two very separate things. Nicaragua case dealt with both of those things separately, but specifically to the point of territorial sovereignty. The court looked at the fact that the United States sent arms across the border into Nicaragua and also trained the Contra forces, the Salvadorian forces, to fight the Nicaraguan government for the purpose of overthrowing the government. There, the situation involved force and a breach of Nicaragua's territory. That can be distinguished from this case because there was no force used in Canada and there was no breach of Canada's territory. The United States agents never crossed over Canada's borders.
But I think that there is some kind of recognition in customary international law now that fraud and other means of non-physical are going to be equated to a physical abduction. And it's American law that that we don't inquire too deeply into how the prisoner was before us. He's here, let's try him. And so it's, is that part of your argument?
Your Excellency, I would distinguish transport or abduction and luring. They're two very separate things, and the fact is, transport or abduction would breach Canada's territorial sovereignty under this court's decision in the Nicaragua case because it involves a crossing of borders. However, courts have found, for instance, in the case of Prosecutor V. Dokunovic, that a defendant who was lured from Yugoslavia into Croatia was not a breach of territorial sovereignty because the luring occurred in Croatian territory. Further, the defendant there freely entered Croatian territory and there was no force used. Similarly here, there was no violation of territorial sovereignty because the defendant freely entered the United States territory and there was no force used against Mr. Rutaganda. Also, it is implicit in the idea of territorial sovereignty that states must have control over an area for it to have sovereignty. Now, on the high seas and in space, no one state has control, so no one state has sovereignty. Cyberspace can be looked at similarly. No one state has control over cyberspace, thus there is no territorial sovereignty. And there is currently no international norm about the sovereignty of cyberspace. The 1927 Lotus case shows us that when there is no international norm, there is no breach of international law. The Convention on Cybercrime was signed in 2001 in the Council of Europe, and that specifically addressed illegal access to computer systems, illegal interception of data, or data or system interference. However, and that is one of the only norms out there about cyberspace. However, that is very different from this case because there was no system interference and no data interception when the U.S. ICE agents sent the email from the United States to Mr. Rutaganda, who happened to be in Canada. Further, Mr. Rutaganda was free to read his email anywhere in the world. This was sent to an email account which has no physical location. If Mr. Rutaganda had been in Spain at the time, this court would not be looking at whether the United States breached Spain's territorial sovereignty or whether it breached Canada's for that matter. It's not even clear where the server was located, whether it was located in the United States or Canada. And again, an email account has no physical location. So the United States could not have breached Canada's territorial sovereignty when it sent the email to Mr. Rutaganda. Finally, Your Excellencies, the United States did not violate Mr. Rutaganda's rights against arbitrary arrest or detention. The ICCPR, the International Covenant for Civil and Political Rights, in Article 9 states that no one shall be subject to arbitrary arrest or detention. Now, it's also important to look at Article 12 of the ICCPR, which states that only those persons who are lawfully within a territory have a right to liberty of movement. The Human Rights Committee has looked at the definition of arbitrary in its commentary to ICCPR Article 9 and found that arbitrariness is unjust, unpredictable, unreasonable, unproportional. However, here, nothing was unjust or unproportional because the United States only arrested Mr. Rutaganda after he illegally entered the territory.
Consul, that was just the United States good luck, wasn't it? Your operation was planned weeks ahead. You had a lot invested in this, and it just so happened that Mr. Rutaganda chose to enter your territory with somebody else's passport. You would have arrested him anyways, is that correct?
No, Your Excellency, there's nothing in the compromise that states that the United States would have had the authority to arrest Mr. Rutaganda if he had not entered the country illegally. In fact,
But you had your president authorize an operation ahead of his entry, and you could not know, or at least facts don't support it, that he would do so illegally. You presume that he would do so illegally. So you had the whole thing set up, regardless of how he had entered. Correct?
The ICE agents were ready to apprehend Mr. Rutaganda, and it's not, there's nothing in the compromise to say why the ICE agents, or whether the ICE agents would have arrested him. Nothing in Mr. Obama's orders said that the ICE agents had the authority to arrest him, even if he had entered on his own passport. The Human Rights Committee has looked at the arbitrariness of somebody's arrest in the case of JRC in Costa Rica. And in that case, the defendant there illegally entered Costa Rica, and he was arrested by Costa Rican officials soon thereafter. His entry was in violation of Costa Rican state law, and thus he had no freedom of movement. That's what the Human Rights Committee found. Here, similarly, Mr. Rutaganda entered in violation of United States law and the law of almost any other state in the world, and he was only arrested after that fact. Thus, his arrest was not arbitrary by the meaning set forth in the Human Rights Committee in the JRC case. Now also, it's important to look at the case of Stocky v. Germany, which is a case in front of the European Court of Human Rights. There, the court found that there was no arbitrary arrest when a defendant was induced to board a plane that he thought was destined for Luxembourg when in fact the plane was destined for Germany. The court there did distinguish the fact that they may have found a violation of his rights had there been involvement.
In your opinion, what's the current state of the law? You're throwing a lot of interesting cases appropriate cases, but where is this going? Is it going one way or the other related to debarring abduction and those various types of acts?
Your Excellency, the state of the law is that the United States and any other country who lures a citizen, as long as once they are in the country, they're arrested legally, which he was arrested legally because he violated the United States laws, that is not a violation of his rights against arbitrary arrest.
But the methodology of getting him into the country, what's the state of the law on that?
If there had been force used to get him into the country, if he did not have a choice of whether to come or not, and if he hadn't entered illegally, or if there had been a threat of force, then it would have been a violation of his rights. However, none of those things were present
Oh,
here.
wait a minute, your Supreme Court said that wasn't an issue in the Mexican abduction case where they went in, took him and brought him back.
The court did find for the mali captus bene detentum theory, which has not been overruled by customary international law, even though Canada points to a handful of states, I think 6 in total, that have overturned that theory. There's no new theory of customary international law overturning that. However, in that case was very different than this one because Mr. Alvarez Machine was abducted from Mexico, and he was forcefully taken across the border. However, in this case,
But you just told me the state of the law, that seems what the state of the law is. If there's a forcible abduction, then that's probably not a good thing, and that the case begins to unravel at that point.
the United States found in that case that they had jurisdiction to try him, even though the means may not have been legal. So here, the United States is not, the means were not illegal in apprehending, getting Mr. Rudiganda from Canada to the United States, because he,
I was going to ask you whether the United States has any question about Canada's assertion of these rights on behalf of this guy. Should only Rwanda be really the party that would be opposed or seeking? Where do they stand in this discussion? Does Canada have appropriate standing to make these claims just because he's a national of Canada?
absolutely, Your Excellency, Canada does have standing to make these claims. However, he is also a national of Rwanda, and they have an interest, as does the United States, in seeking international justice because Mr. Rudiganda is suspected of committing the murder of 275 Tutsi children in the course of the Rwandan genocide.
So, should that be a factor that we should be considering, that there's this other party of interest not represented here that has an interest in this matter?
That is not before this court today because Rwanda is not a party to this claim. However, the United States does have an interest and an obligation under international law, under the Convention on Genocide, to seek Mr. Rudiganda's prosecution because his crimes that were committed were genocidal in nature.
Why don't you wrap up, Karen?
Opposing counsel has pointed to no cases where the Human Rights Committee, which is the monitoring body of the ICCPR, has found trickery a violation of human rights. And again, in absence of a prohibition, there's no violation of international law under the Lotus case. Finally, Your Excellency, in conclusion, the United States acted in accordance with international law when it enticed Mr. Rudiganda into the United States. The United States did not violate Canada's territorial sovereignty, did not violate the extradition treaty or the exchange of letters, and it did not violate Mr. Rudiganda's human rights.
Thank you, Counselor. Please proceed.
May it please the court, my name is Sarah Kane, agent for the respondent, the United States of America. There's a long-standing principle in international law that a sovereign state may act as it chooses so long as it does not violate international law. At issue here today is whether the United States transfer of Mr. Rudiganda to Rwanda would violate international law. Canada argues that it would, but can offer no binding principle of international law that prohibits not violate international law for 3 reasons. First, there is no binding principle of international law that prohibits transfers in the absence of a treaty. Second, there is no binding principle of international law that prohibits the prosecution of crimes committed at the age of 15. And third, Rwanda is capable of providing its criminal defendants a fair trial. We first argue that Mr. Rudiganda's transfer would not violate international law because there is no binding international custom that requires the existence of an extradition treaty. International custom is only formed when there is general state practice done out of a sense of legal obligation. It is true that extradition treaties have been entered into it increasingly in recent years, and this might suggest the existence of state practice. However, there is no evidence that these states enter into these treaties out of any sense of legal obligation. Rather, it is more accurate to say that they enter these treaties because they are more convenient to do so rather than deal with extraditions on an ad hoc basis. This is evidenced by the language in the preambles of many extradition treaties in force today. Most notably, the preamble to the extradition treaty between Canada and the United States says that they entered the treaty to make repression of crime more effective between the two countries. Such language suggests that rather than entering extradition treaties because international law requires them to, they do so more for the convenience that the treaties provide. Because a sense of legal obligation is lacking, there is no international custom binding on the United States that prevents it from extraditing Mr. Rwanda in the absence of a treaty.
You have an extradition treaty, counselor, and yet the United States goes ahead and lures this young man across the border. Why didn't they just go ahead and work with the Canadian government and work this out, despite their verbal position on this?
As my co-agent has expressed in our earlier argument, we did not feel that the luring violated the terms of the extradition treaty, and that the extradition treaty was not the sole means of concluding the transfer of Mr. Rwanda from Canada to the United States. However, we are arguing in this case that there is no binding custom of international law that prevents the transfer of Mr. Rwanda from the United States to Rwanda. We recognize that a transfer, whether with or without a treaty, must ensure that Mr. Rwanda will not be subject to torture and will be guaranteed a fair trial. While we argue that he will be afforded a fair trial as our last point, we argue here that Mr. Rwanda will not be subject to torture in Rwanda so as to prevent his transfer.
You know, the United States has an interesting position on this with its secret camps and its conditions of individuals, not very unlikely this individual here. Doesn't this look like the same thing has been happening over the past 8 years in other parts of the world? The extraction of human beings to other countries and potential violation of various customs as well as law.
We argue that this would not violate international law because we ensure that Mr. Rwanda will not be subject to torture and will be guaranteed a fair trial.
How do you know that? You're asserting this rather clearly and straight up. How do you know that?
The Human Rights Committee has set out a test to determine whether an extradition should be blocked. And it is said that no extradition is to take place where there is a substantial grounds for believing there is a real risk of irreparable harm. The Committee Against Torture has said that this can be determined by looking for systematic practices of torture in that country. And we submit that there is no such systematic practice in Rwanda. Look, for example, to the case in 2004 in the United Kingdom, known as AG Rwanda versus Secretary of State. That court addressed whether Rwandan prison conditions amounted to torture and looked to see whether there was a systematic practice of torture within its national prison.
Counsel, are you telling us that that's the only criteria?
It is not the only criteria.
Isn't it the correct, and I apologize, but that according to the other criteria, no other state has transferred any detainee to Rwanda for prosecution because of their concerns for a fair trial. Is that correct?
That is with regards to fair trial. However, with regards to torture, and we do submit as our last point that they will be reported a fair trial. However, in regards to torture, and as a matter of fact, the Special Court for Sierra Leone in November of 2009, transferred 8 convicted prisoners to a prison facility in Rwanda to serve the remainder of their sentences.
Why is that important?
It's significant because it highlights the growing capacity, or the capacity of Rwanda to provide a prison environment that meets international standards. The Special Court found that the prison standards at this facility met the standards as dictated by on the treatment of prisoners.
I don't recall, was there any objection by other states parties or their management committee as to that transfer?
Not to my
concerns?
knowledge, I do know that the convicted prisoners did appeal it, however, I do not know more than that.
Okay, proceed.
We urge this court to allow this rendition, particularly because there is international custom that requires states to extradite.
Whoa. There's another verb here tonight. Thank you for your English lesson, Judge. Rendition, now we're talking, are we rendering this individual to Rwanda?
We prefer to use the terms rendering or transferring because this is not technically an extradition as it is according to an extradition treaty.
Well, what's the difference between extradition and a rendering?
Rendition is, extradition is a type of rendition. Extradition is formal procedure in order to surrender a indicted person for criminal prosecution in the requesting state.
Okay, and what is a rendering?
Rendering is simply the transfer of, it could be broad as, it could apply to suspected individuals, it could apply to evidence. It's just the transfer of personal materials from one person to
Almost
another.
deportation.
Deportation can be a type of rendition, yes.
Counsel, isn't it correct that the United States has a statute under which it could itself prosecute Mr. Rutana without deporting him? Or
Yes,
rendering
correct.
him, as you want to say, to Rwanda?
Yes, we do have that statute. However, we do feel it is in the best interest of Rwanda to prosecute this individual because the crime occurred there and they are the victims, but the victims all reside in that country. Justice is best served by having the case heard in that country.
So what are you going to do to render him or deport him?
Technically, it is deportation proceedings.
Thank you. That would be helpful to this court.
We argue that there is an international custom requiring states to extradite in order to prosecute serious crimes of international law. There are two widespread multilateral conventions that include such provisions, and because they are so widely ratified, we argue that they form a binding principle of international law. We consider, for example, the Convention Against Genocide and the Convention Against Torture, both with over 140 state parties, and both containing a provision directing its states to extradite in order to prosecute crimes of genocide and torture. Here we are dealing with the crime of genocide. The indictment says that Mr. Rwanda has been indicted for the murders of 275 Tutsi children in the course of the Rwandan genocide. And as a party to the Convention Against Genocide, the United States is under an obligation to cooperate with Rwanda in extraditing Mr. Rwanda.
So the terms of the indictment doesn't make a difference? The fact that he's charged with murder and not genocide, according to you, doesn't make a difference?
We argue that the indictment, because it includes the term in the course of the genocide, that it does amount to a crime of genocide that he has been indicted for.
However, Rwanda, correct me if I'm wrong, has been prosecuting genocide cases, charged people with genocide and prosecuted and found guilty or acquitted them with that specific charge. Is there something to be said for the fact that they chose not to indict him for genocide?
There's nothing in the complaint or its clarification that suggests
No,
that.
I'm talking about the legal implication of the fact that he is not charged with genocide.
We submit that he has been, due to the terms of the complaint and the clarifications which say that it's murder in the context of genocide.
Does the Convention and the Prevention of Genocide talk about the crimes committed within the course of a genocide, or does it talk about genocide?
It criminalizes complicity in genocide, and that is what Mr. Rwanda has done here.
But was that what he was indicted for?
It is what he has done here.
All right.
We next argue that the rendition of Mr. Rwanda would not violate international law because there is no binding rule that prohibits the prosecution of crimes committed at the age of 15. The prosecution of Mr. Rwanda would only be prohibited if there were a treaty obligation or a custom of international law that prohibited prosecution.
Yes, let me ask you, I'm thinking that you made a kind of a slip on torture and then you just kind of moved on. So you're saying that the United States feels that those who have tortured in the world need to be handed over for a fair trial somewhere and whoever asks for it. Is that what you're
Because
saying?
it amounts to a serious crime of international law, it warrants prosecution, yes.
By who?
By whoever is willing to, and in this case, it is Rwanda.
I see. What would happen if Spain notified the Justice Department that they would like them to hand over Lieutenant General Ricardo Sanchez because they felt that he was torturing people in Abu Ghraib? What would be, based on your logic there, the U.S. position on that?
If the U.S. had I'm not too familiar with that case. I would imagine there's no treaty obligation that prevents the prosecution of Mr. Rwanda. The Convention on the Rights of the Child does state that there is a minimum age of criminal culpability under which prosecution would violate the terms of the treaty. However, the Convention gives little indication as to what this age should be.
Also, isn't it correct to say that the ICC statute would be on this point the latest manifestation by untreaty of what the customary international law is? And isn't that correct that that specific statute prohibits the prosecution of anyone under 18? Is that correct?
That statute does prohibit the prosecution of anyone under 18 within their borders.
And wouldn't you say that that reflects what is now customary international law in terms of the prosecution of child soldiers?
It could be if it were more widespread than just the practice of the ICC.
How many countries have signed the ICC statute?
A number of countries, however, this does not necessarily mean that this speaks to whether or not a state feels that that should be the minimum age of criminal responsibility in international law. If this court would look at the minimum ages of all across the world, one would find that they actually expand the ages of 7 to 18.
And how can a country express, let's say for the sake of argument that the ICC statute does reflect customary international law as it stands now on the subject, how does a country express its dissent
If they
from the customary
persistently
international
objected to the formation of that law. However, a state would not have done that as it signed on to the ICC simply because those jurisdictions said just for that court and not as an international standard for all countries to be bound by.
United States is not like the ICC.
But as the United States constantly expressed its opinion that child soldiers should be prosecuted for international law.
We do believe that child soldiers should be prosecuted, yes. States enjoy considerable freedom in setting minimum ages for criminal culpability. The United Nations Standard Minimum Rules for the Administration of Juvenile Justice has acknowledged that the different cultural or social factors within a country would dictate varying minimum ages throughout the world. And as I noted just earlier, these ages actually range from 7 to 18. Canada itself has set its minimum age at 12 and thus would have this court prohibit what is actually legal within its own courts.
What crimes are we talking about? Are we talking about breaking and entering? Are we talking felony crimes? Are we talking international crimes, war crimes, crimes against humanity? What's the distinction here? The court fully acknowledges that domestic courts prosecute children.
The Canadian Criminal Code does not distinguish particularly what type of crimes could be tried. However, we do argue that Mr. Ruwanda's status as a former child soldier who committed crimes of genocide should not be exempt from prosecution. While it is possible that a child...
Isn't the trend, despite the customary international law possibility, but isn't just the thinking is that the children just don't have the capability under the age of 18 to have the mens rea to commit a war crime?
Yes, this opinion has been expressed in numerous statements. However, these are at most policy documents that are not binding on Rwanda yet. Even the Paris Principles, which emphasize that child soldiers should be viewed primarily as victims, do not suggest that child soldiers should never be prosecuted. They only suggest that states should prosecute child soldiers with their status as a juvenile in mind. While it is possible that a child soldier's specific circumstances might dictate that there is no culpability to be found, it is also entirely probable that a child soldier does bear some responsibility for his actions. This is a determination to be made based on the specific circumstances at hand in a trial setting and not by a bright line rule that allows soldiers to commit any crime with impunity because they are under the age of 18. There is a strong possibility that Mr. Rwanda here bears at least some level of culpability because he was 15 at the time that he took part in the Moot massacre, and he should be prosecuted in order to determine what that level of culpability is. As a final note on the matter, it is apparent that prosecution at the age of 15 does not offend the international community's conception of what is too low an age, but denying this prosecution does undermine the notion of international justice. This is especially true in a country where the victims of genocide will see perpetrators of lesser and more trivial crimes prosecuted, while seeing those who have committed crimes of much greater magnitude walk with impunity. And this is unjust in a nation that considers those at 12 as responsible for their actions. In light of the gravity of his crimes, and the fact that Mr. Rwanda was not too young to take responsibility for his actions, this court should not allow Mr. Rwanda to escape with impunity. Finally, we argue that Mr. Rwanda's rendition would not violate international law because Rwanda's legal system today is capable of affording him a fair trial. There is little question that Rwanda's legislative framework meets minimum standards. Rwanda amended its constitution and its criminal code in recent years to ensure that criminal defendants were assured all
By
of
little question, what do you mean by there's little question? You sound like this is just a definitive situation.
As far as legislative framework goes, the International Criminal Tribunal for Rwanda has stated in its jurisprudence that Rwanda does possess the legal framework to provide a fair trial due to the reforms it has made to its constitution and to its criminal code, as well as a transfer law in 2007 that it passed to govern transferees such as Mr. Rwanda.
Would it apply to him?
Yes, it would. As the transfer law applies specifically to those who are transferred through the ICTR and extradited from other states.
He's not
However,
being extradited, though.
in essence, Your Excellency, this is an extradition. However, in a series of cases, the ICTR has held in 2007 and 2008 that though Rwanda had the legislative framework necessary, it was not providing a fair trial in practice. Since then, Rwanda has undertaken extensive reforms in direct response to the criticisms of the ICTR and the international community. For example, the ICTR cases primarily hinged on a lack of witness protection for defense witnesses. In response, Rwandan officials underwent witness protection training by the ICTR in 2009 and secured donors to provide video link technology for witnesses who could not be present in Rwanda. There was also a fear in the ICTR cases that transferees would be subject to life imprisonment in isolation due to an ambiguity in Rwandan laws. In direct response, Rwanda amended its laws to expressly state that transferees would not be subject to life imprisonment in isolation.
Counsel, Canada made the point that according to the organic law of Rwanda, someone who testified on the behalf of an individual who is accused of genocide could himself or herself be subject to prosecution for promoting genocidal ideology. Do you equate that with the right to a fair trial?
Could Your Excellency repeat that?
If you testify on behalf of somebody who's accused of genocide in Rwanda, you could be subject yourself to promoting the ideology of genocide, as is a crime in Rwanda, as had happened in the case that your colleague cited to us. Do you think that this is indeed a guarantee of a fair trial? If your own witnesses will really come forward, even though they may themselves face prosecution? Isn't that one of the criteria that the court ICTR used to refuse extradition?
The ICTR case is primarily hinged on witness protection. We do realize that there is a cause for concern there. However, it is not overriding Rwanda's interest in prosecuting this crime.
But is that correct that Mr. Rutaganda would be a guinea pig because no other jurisdiction has transferred any prisoners to Rwanda because of those concerns? Is that correct?
However, it's important to recognize that Rwanda has set apart an entire legal scheme that covers transferees specifically, and it has never had the opportunity to exercise this legal scheme because no one has transferred an individual yet. We do not ask this court to blindly send Mr. Rwanda to Rwanda because we point to the many and extensive reforms that Rwanda has undergone in order to ensure that it can provide a fair trial. This court should not judge Rwanda's ability to provide a fair trial based on the decisions of the ICTR because the ICTR based its decisions on the state of Rwanda's legal system as it was in 2008. The justice system that this court would transfer Mr. Rwanda to is simply not the same justice system contemplated by the ICTR. This court should instead focus on the substantial measures that Rwanda has taken hand in hand with the ICTR in deciding whether Rwanda is capable now of providing Mr. Rwanda a fair trial. To argue that Rwanda has not demonstrated the ability to provide a fair trial to transferees is inherently unfair because Rwanda will never be able to do so until the transferee is transferred. And Canada can offer little evidence that Rwanda's reformed legal system as it is today cannot provide a fair trial. And then until there is such evidence, Rwanda should be free to prosecute Mr. Rwanda.
What about the Brown case?
The Brown case was decided, I see my time is up, may I address your
Finish
question?
the question.
The Brown case was decided in April of 2009. However, it was an appellate court decision that was based on the facts presented to the lower court in 2008, and thus still based on the system that was in place in 2008. There was actually a court decision by the Swedish Supreme Court in May of 2009 that examined the fair trial system in Rwanda and said that a man named Mr. Orogezi was extraditable to Rwanda.
Thank you, Counsel. Representative from Canada, I believe you have a few minutes. Please.
May it please the court. Excellencies, Canada has 2 points which directly relate to the outcome of this case. First,
The respondent contended that the United States had an obligation to intercede on behalf of Mr. Rutaganda. This is simply false. Mr. Rutaganda was charged with murder, not genocide, crimes against humanity, or another Jus Cogens level crime which would have connoted universal jurisdiction to the United States. The parties have stipulated to this fact in paragraph 4 of the compromise. Therefore, the respondent's reliance on the Genocide Convention is misplaced. The United States may also not rely on the Interpol Red Notice because Interpol Red Notices are not binding. They do not connote any authority or any obligation on any state. Therefore, Canada was well within its rights when it refused to extradite Mr. Rutaganda. And the United States' involvement in this case was not in contravention. The United States' involvement in this case was in contravention of international law because the United States did not have universal jurisdiction because Mr. Rutaganda was charged with murder. And as Your Excellency noted, the district courts in Rwanda have charged murder in the past, or excuse me, have charged genocide in the past, could have done so in this case and have not. So it is therefore quite important to this determination that the charge present is murder. Excellencies, Canada's second point is that whatever term the respondent uses to characterize the transfer of Mr. Rutaganda to Rwanda, his transfer would be illegal because Rwandan District Court cannot currently guarantee Mr. Rutaganda a fair trial. There's numerous evidence from 2008 and 2009 in support of this. For example, the 3 transfer cases from the ICTR in 2008, which all held that the defendants could not be transferred to the district court. While it is true that they include considerations of the Witness Protection Program, responding counsel's discussion of those cases is incomplete. They also found that the Rwandan district courts did not have judicial independence, and this was a primary determination in their refusing to transfer. Your Excellency noted the 2009 case of Brown versus the United Kingdom. There are also cases from Switzerland, France, and Finland that have denied transfer to the Rwandan courts because they are not fair. The United States cited the 2009 Swedish case of Aharugezi, but failed to mention that the European Court of Human Rights has stayed that defendant's transfer to Rwanda upon further determination of whether the Rwandan district courts are fair. Therefore, the United States has cited no cases that have found the Rwandan district courts to be fair and transferred defendants because there is no such case. Your Excellencies would in fact be setting international precedent by allowing for the prosecution of a child soldier, since this has not been done since the Nuremberg tribunals. Therefore, Canada respectfully requests the court find in its favor.
All right, this court will retire to deliberate and thank the parties for their arguments. This court is closed.